they're actually making money off of this every year, and the tax liabilities are tied to it, and they have no idea? Hi, this is Jeff Marsace, the Plain English Attorney, and today I'm going to go over 4 things that your estate planning attorney is very likely to not have on file. Unfortunately, this video is being done because lately we've been getting a lot of strange requests from family members of estate planning clients who may have passed on, or they're incapable of handling financial things on their own, and they're calling us up because other professionals are telling them, well, you need to get this information. Your estate planning attorney should have it. And it's just been ridiculous. All right, since it's baseball season, a lot of our filming is going to be done out here at the Durham Bulls Athletic Park. So, okay, the Bulls did bring me back. All right, so what's one item that's definitely not something that your estate planning attorney is going to keep on file? Copies of medical records. When we end up with anything actually related to medical records, typically it's some kind of written doctor's note on a client's capacity, whether they're capable of executing documents or not, or they're not capable of handling their own affairs anymore. There's a diagnosis of dementia or something like that. That's typically the only thing, other than the healthcare power of attorney or the living will. That's stuff that we keep on file if we're the ones who created those documents. But we've actually had clients request copies of their medical records. We just don't have that stuff. And I don't know of any estate planning attorney that really does keep that information around. Okay, Jeff Marsace, Plain English Attorney. I'm here with Jacoby, the on-field announcer for the Durham Bulls, and I just have a quick question for you. You have an estate planning attorney, someone who's done your wills, trusts, powers of attorney. Do you expect them to keep copies of your medical records?
Medical records? Why?
Exactly. Right. Second thing that your estate planning attorney is not going to have in their regular files: copies of tax returns. Unless there was some kind of tax issue that they were also helping with incidental to putting together your estate planning documents, there's really no reason why your estate planning attorney would have copies of tax returns. Even when we're doing Medicaid planning, it's not something that we typically have or keep. Occasionally it comes in handy trying to generate the plan to see actually what's going on, or to hunt down assets. But most of the time it's not the planning attorney who's putting together irrevocable trust, or even the overall strategy, who would have that. It's typically an accountant. But once again, we got a request for copies of tax returns for the last 5 years for someone who passed on. We don't have that. You should check with your accountant. Oh, do you think they would have it? Well, if they did the taxes, very likely. Okay, third weird thing, and this has actually happened in the last couple of months, that we've had families of our clients call in and ask for copies of all of our clients' bank statements for the last 5 years. All right, estate planning attorneys don't keep that stuff. It actually does kind of become a little relevant if they're applying for Medicaid, because the Medicaid office, in examining the application, they want to see 5 years worth of all the bank statements. But this isn't stuff that estate planning attorneys are routinely keeping in their files. When we put together an estate plan, and in fact, when we initially put together legal stuff related to a Medicaid planning case, we don't need that stuff. we don't need bank statements, we just need balances. When it comes time for the application, then it's always good to have the statements to see is there anything that the Medicaid office will put a little red flag next to it and say, hey, we need to look into this. But this isn't stuff that we just keep. Anything can be dramatic at the right frame speed and with music in the background. Okay, and the last thing, and this is really ridiculous, only because of where it came from. The fourth thing you shouldn't expect your estate planning attorney to have is cost basis information on stock that you have with a financial advisor. Cost basis is when you have, here's the value you bought stock in on, and then if you sell stock at a higher price, we need to know what was the gain for computing capital gains taxes. So this is routinely stuff that financial advisors should have or have the ability to get to. But there's one financial firm twice within the last 2 months who have said, oh, well, you need to get in touch with your estate planning attorney and get that cost basis information. We need that right now. And this was for deceased clients. We don't keep that stuff. I have no idea. We're not the financial advisor. That stuff either they're keeping or they know how to get. And I was talking about this with a colleague of mine. They're being lazy in trying to track down that information that they need. Look, we don't keep it. You can't just shove that off on an estate planning attorney. Really, can you believe it? They're actually making money off of this every year, and the tax liabilities are tied to it, and they have no idea, and they're trying to get people to come to me. That's how ridiculous it really sounded. So that's the fourth big thing. So those are the 4 big things you should not expect your estate planning attorney to have kept in your file or anywhere else for that matter. So I hope you found that information useful. I ask, please go ahead and subscribe. It really helps the channel. And when you do, go ahead and comment below that you subscribed, and we will do our best to get back and comment to you and see if there's any questions you've got. So as always, please stay safe, plan ahead, and enjoy life, and whatever you do, make it a great day.